We thank you for watching Law School Made Easy at Law School Made Easy 256. You find that in semester 1, when you're handling contract law, we are only forming a contract. This is the semester where you form a contract. You find that in semester 2, we shall now look at things which vitiate a contract, which make a contract go like which vitiate. Vitiate means things like fraud, misrepresentation, mistake. But in this semester, as you answer your exams, you are only forming a contract. So your emphasis should be put on is this contract valid? Is this a right contract? Does this contract have the elements of a contract? So it is against that background that today in this video we are going to look at how to answer a contract examination. How to answer a contract examination. But before we enter into that, we thank you for subscribing, sharing, and always liking our videos. So today, our main focus is on how to answer a contract examination. And some of you are going to go for the exam, and the paper before you is contract. So we are saying, let us try to pick on a few tips on how to answer that contract paper which is before you. Number one, the first thing you must know is this semester, how many topics have you covered? It's very important. We know that literally in this first semester, you have covered offer, acceptance, consideration, intention to create legal bound, a capacity to contract, and contents of a contract. In there, you have exclusion clauses, you have representation and mere representations and contractual terms. So, and to some institution, you go as far as agents in this semester. Other institutions, agents will be in the second semester. However, now that we know the topics we have covered, the number one rule as you enter into a contract examination, first understand how many topics have you covered. And these topics should be on your fingertips. No, apart from only knowing that these topics, I know them, do you even know what is in there in those topics if we begin to break? So that is the first thing you do as you enter into a contract paper. The second thing is for you to know why this semester, what is so important in this semester. Now, what is important in this semester? We are forming a contract. So we are saying that for every question you are about to answer, is it a valid contract? Was there a contract? Do you see the elements that form a contract surfacing in every question you're going to find? So we are saying number two, you must know that this first semester, we are only and only forming a contract. That is why if you study about, let's say, capacity contract, that is where they are telling you that a minor, if a minor is engaged in a contract of service, apprenticeship, then a minor will be held liable. Look at Roberts and Powell. So we are saying, but again, they are telling you that a minor is not liable to make certain contracts. So we are only forming a contract. Then, if you look at intention to create legal bounds, they are telling you in Barufa versus Barufa that social contracts do not amount to a contract. However, in Petit versus Petit, where you sign, there is a signature, then those social contracts can amount to a contract. So I think now you can see that we are only forming a contract. That is the second principle you must enter with if you are entering to do a contract examination. Now, let's go to when this paper is now given to you. You are now in an examination paper and you have this question before you. What is the first thing we expect you to do? Number one, read through the questions and understand them. Read through all the 8 questions I'm sure your papers are 3 hours and 30 minutes. Now, use the first 10 minutes to read all the questions, to have a clear view of all these questions. Number one, as you read each question, don't spend much time on it. Just read the 8 questions if there are 8. If there are 7, just read. You are now opening your mind to the first 2 things we talked about, to the topics that you now know, and also to see which topic is where. As you read question 1, you note, this is consideration. You go capacity contract. You note this one is category D. This one you leave it out. You go to number 4, intention to go about. Number 5, exclusion clauses. Number 6, this. So after the first 10 minutes you have read through, you now know all the topics which have been said. And now in your heart, in your mind, these things are running. I'm going to do acceptance, consideration, exclusion clauses, and capacity. You see how you're even able now to choose, because on your reading you have seen that those topics have been set in those areas, and in your preparation you were ready to answer, let's say, capacity contract. You were ready to answer, let's say, intention legal bounds, or you're ready to answer what to say, let's say, consideration. So that is the third bit that you must do. Now you have identified all the topics which have been set in that question. Now choose, decide on which numbers to do. Now this is optional. Those of you who can, use the next 20 minutes. If you have really identified the topics and you have understood in the 10 minutes of reading the question, now use the next 20 minutes to summarize. Summarize on the first page. Some students do not want to summarize. They are how do we call them? They are genius. They can't summarize. For them, everything is from the head, but you will forget. Good students always summarize. Summarize question per question. Just to remember the cases you're going to use, the points you want to note down. For example, if you notice that the question is about consideration, you begin noting your cases on consideration. Twedo, so La Scola, High Tree, Combe versus Combe, Thomas versus Thomas. You note down all the cases you intend to use, all the points you want to use in that regards. If there are types, you note down executed, past consideration, and then you go tagging each with the case. It will help you, because when you begin to write, you don't have time to think a lot. But if you look at a case, Rascola versus Thomas, you remember this is past consideration, then you begin to write. So it becomes easy. So all good students will summarize on the first page or second page of your booklet. No one. But remember to always cancel. Remember to always cancel that work. So now you see, we are now left with strictly 3 hours that we are going to use to answer the 4 questions. Now, let's assume one of the questions you have picked is a problem question. Now, you go to your problem question. You begin by summarizing the facts you have. You write all the brief facts. And remember, brief facts are supposed to be brief. Brief facts are supposed to be brief in contract. So you have about 5, 6, at most 8 lines. But brief facts should be brief. And after you have written your brief facts from the facts which were given to you, then now you go down and now you write the issues arising. Not me here. Because we are forming a contract, it depends on who is teaching you. But the first issue always, in my opinion, should be whether there is a contract, such that you define a contract. If it is a problem question first year, such that you clearly bring out what you understand by a contract. So your first issue should go whether there is a contract. In the facts given to you, whether there is a contract. Then, of course, I'll come to, then you write the other issues, but I will solve issue 1. Then you write the other issues that you have seen. You should not exceed 4 issues, really. If you must go far, you stop on issue 5. But more than issue 5, you are being too wordy. Make sure that even if you write 3 issues, you are able to exonerate all the issues in these 3. So if you have about your 4 issues, because even time won't allow you to have 6 issues, to have 7 issues. It is too big. Yet you can even have 2 issues, but you make sure in the 2 issues you have explained everything. But in this case, because we are first years, let's handle 4 issues. Now, after you give us the law applicable. Now, in the law applicable, you can never leave out the Constitution. The first law you're going to refer to or to use is the Constitution, and then the Contracts Act. Remember, the cap has changed, and now you put the Contracts Act. After putting that, you now also put cases that you're going to be resolving using cases. Now, after you have written your law applicable, you now resolve. Resolution. But remember, our issue 1 was whether there is a valid contract. You begin by telling us what you understand by a contract. Because remember, these exams, you are showing your lecturer that, look here, I understood what you taught. I understood what you taught us. So you're telling your lecturer, number 1, that there was a valid contract. And then you say section 2 of the Contract Act defines a contract as an agreement enforceable by law, and further expounded in section 10 of the Contract Act that says an agreement is an agreement entered in with free consent, with capacity to contract, lawful object, intention to create legal bounds, and the lawful object. So you explain section 10 very well, and after you even give, we have a locus classicus case that defines the elements of a contract. That is William Kasozi versus DFCU, and then you tell us what was held in that case. By so doing, you have established that the facts which were given before you, there was a contract or there was no contract, since you have told us the elements which form a valid contract. Now you begin to answer the other issues. If you see that there was an issue, let's say, of consideration, then you come and give us cases of past consideration or executed consideration. So that is how you go about a problem question. But remember to resolve. Every issue you handle on a problem question must be resolved independently. But according to the facts given before me, there was a valid contract. Because from the facts which are here, I can see so and so sold this to this, and this in this element there was acceptance, offer, and consideration, and also intention to create legal bounds. So that is definitely how you go about a problem question. Don't forget to resolve. But we have said it's important, always the first issue should be in this first semester whether there was a valid contract, and then explain to us and also give us that case of William Kasozi versus DFCU. Now, you are done with that. Now, the minimum, I am talking about the minimum cases we want per issue is 3 or 4. Lecturers will request a minimum. If you have 4 issues, that means you are now giving almost 12 cases or 14 or 16 cases. That is okay. The minimum cases should be 10 on that problem question. If it is consideration, you explain. Rascola versus Timothy. There, it was clear definition of clear definition of past consideration. Then you give another Rimacado's case. What happened in there? Was consideration successful there? So in simple terms, try hard to show the lecturer that you know of a case where a matter succeeded and you know of a case where a matter failed. So in that way, you have given all the sides. You have given all the sides of the coin. You can even give a bonus. So an implication is that at least on every issue, if you have time, you can even put five cases. But if you know you are not good at reading cases, at least the 4 cases can work on one issue. You leave that whole question of a problem question with about 16 cases or 12 cases. Now, let's go to what they ask as short notice. You find they have told, they tell you, write short notice about the following, and they give you 5 or 6 elements where you're supposed to choose 5, and each one of them has 5 marks. For example, they can say, what do they normally ask senior counsel Simon? Let's say doctrine of equitable restitution, and that is number 1. They tell you implied terms. They tell you conditions, warranties. Now they are telling you 5 marks. Colleagues, 5 marks doesn't mean write 10 lines. The minimum you can go on conditions or warranty, just that warranty, is a full page or 3/4 of the page. You explain what that warranty means or what a condition means. You give examples of warranty, and then you give cases explaining those warranties, or a case explaining the equitable restitution of doctrine of restitution. They can even ask minors. So if it is about a minor, exhaust a minor. When is the minor liable and when is the minor not liable? What happens if the conditions are harsh for a minor? All those elements, you're going to explain them. The minimum you can write, if you have a very good handwriting, is 1 page. If your handwriting is like the one for Counsel Simon Wataro, then you need to write on 1.5 pages or even 2 pages to be able to get the 5 marks. If you have 6 cases on that, only minors give them. Just learn how to calculate your time, how to be fast. But don't say I just simple marks. I'll just write a definition of what a condition is and you go away. No, it will not fetch you any marks. Hope we are clear there. Now, we can now go on block questions. Block. It is just a block question. Maybe they are asking about no scenario. Maybe let's say ask about exclusion clauses, and it's block. They are asking you how they work, how they are applied, or all those things. So you know that there are 3: signature, notice, and usual dealings. Yes, but begin by telling us, how do we arrive at that exclusion clauses? First, appreciate them, and then enter us into those 3: signature, notice, and usual dealing. And give us, if you give, for example, a case, let's talk about notice. If you give a case in notice and say that people want to escape liability when they put notices ABCD. Now, you give us a case, for example, Marlborough, the case of Marlborough Hotel. Now, if you give us that case of Marlborough Hotel, where a notice was put in a room and these people saw it, but again, the Marlborough Hotel was made liable. Now, give us another case where the hotel or any other place was not liable. For example, their notice was on where a contract was signed from. Their notice was on the front desk give us another case. That is how you are able to explain. If you say that in Marlborough Hotel, these guys were held liable simply because the notice was in the room and it was never brought to the attention of the plaintiff. Now also give us a case where a notice was brought to the attention of the plaintiff. If you are saying in usual dealing, if you give a case of Wuria versus Rabo Motors, then you are saying that 2 to 5 years cannot amount to usual dealing. Now, give us another case saying that if you work ABCD, this can amount to usual dealing and your liability will be ABCD. Exonerate, like give the whole topic. Explain everything you know. I think we have now talked about all forms of questions which are asked in contract law. But finally, this is not to mislead anyone. Finally, if you want to talk about contract, in this semester, if you feel you are stuck, write whatever you know about that topic. The lecturers will sort out. Write whatever you know only for first semester. If you feel you're stuck, write whatever you know. If you feel a topic is about intention to create legal bounds, write about merit, petit, balfa, Jones Padapaton, corporations, write everything about the topic. The lecturer will sort out. So we want to thank you so much for watching Law School Made Easy at Law School Made Easy 256. Stay tuned, subscribe, share, and also like our videos. Thank you.